education, and legislation affecting access to gender-affirming care for young people. These conversations, as everyone in this room I think knows very well, come at a very important moment. Courts across the country and here in Ohio are grappling with the scope of parents' rights to direct their children's medical care while also navigating the evolving legal landscape following the Supreme Court's decisions in Dobbs and Scarametti. Here in Ohio, the Supreme Court is currently considering whether to overturn a lower court order blocking enforcement of a law prohibiting hormone treatments and puberty blockers for transgender minors. In Florida, an appellate court recently struck down a law allowing minors to seek judicial permission for abortion without parental consent, holding that it violated parental rights. And across the country, access to contraception and sex education continues to be affected by changes to federal family planning programs. So we are very fortunate to have an outstanding group of speakers with us today, scholars, researchers, advocates from around the country, who will help us better understand these developments and to think through their long-term implications. This conference reflects our law school's commitment to advancing cutting-edge legal scholarship and advocacy, and it builds, as I mentioned before, on our nationally recognized strengths in health law and in social justice. So I'd like to thank the funders of the Reproductive Rights Law Initiative for their support, and of course, thank you all for being here today. And with that, I'd like to turn things over to Jesse Hill, our director of the Reproductive Rights Law Institute. Professor Hill.
Yeah, thank you, Dean Rose. I am so delighted to be here welcoming all of you to this conference. As Dean Rose mentioned, I'm the director of the Reproductive Rights Law Initiative here at the law school, and also the Judge Ben C. Green Professor of Law. The mission of the Reproductive Rights Law Initiative at Case Western Reserve University, which is part of the Law Medicine Center here, is to preserve, protect, and expand access to abortion and reproductive health care in Ohio and throughout the Midwest. The RRLI works to preserve and advance the legal right of all Ohioans to make their own reproductive decisions through advocacy, including litigation, scholarship, and education, which includes training and inspiring the next generation of attorneys with expertise in reproductive rights, and offering public education through free webinars and live conference events like this one. As the only law school-based program of its kind outside the East and West Coasts, the presence and visibility of the RLI sends a compelling message about the importance of reproductive rights in the Midwest and the need to continue efforts to protect and expand them. Today's conference was the brainchild of Katie Corwin, who you'll hear from next. Katie is the RLI's legal fellow, and she's put a tremendous amount of work into making this idea a reality. I'm so thrilled to see the incredible lineup of speakers that she's brought here today. And as Dean Rose noted, this is just a very timely and important topic at this moment in the US, especially sort of post-Dobbs and post-Scarametti. This conference also continues the RLI's tradition in its few years of existence of combining cutting-edge academic research with practice by including a mix of academics, researchers, advocates, and others, and placing them all in conversation together. Like most such events, this conference took a tremendous amount of work to pull together. In addition to recognizing Katie, I want to acknowledge the efforts of many others as well. Natalie Gemiola, the RLI's program manager, and Alita Cowan, our department assistant, have worked tirelessly to make sure everything runs smoothly today, and equally importantly, to really get the word out about this conference. It may not look like it this early in the morning, but I'm very happy to say that we actually had to close in-person registration early because we were at capacity for this event. I'm sure they're on their way. And we have over, I think, last count, over 150 people registered on Zoom, maybe more at this point. Finally, Eric Seiler, the law school's director of academic centers, and our fabulous tech folks, including Martin Raska, Rob Combs, and Dave Wright, have also provided invaluable support. And I want to thank our co-sponsor, Social Justice Law Center here at CASE. And then finally, I want to acknowledge the RLI's many individual donors and foundation funders for their support. Of course, none of this would be possible without them. So with that, I'm going to turn it over to Katie Corwin. Thank you.
Good morning, everyone, and welcome to Case Western Reserve University School of Law for our event today, Repercussions of the Barriers to Care, Youth Access, and the Fight for Bodily Autonomy. My name is Katie Corwin, and I am the legal fellow here with the Reproductive Rights Law Initiative. I began to conceptualize this conference about a year ago, and I'm so excited to see it come to fruition. We will discuss this more in depth at our second panel, but here in Ohio, minors seeking abortion care are required to obtain parental consent. For those who cannot involve a parent, there is a legal process called judicial bypass, where a young person must go to a court and ask a judge for permission to make that decision themselves. I've been representing minors in these judicial bypass proceedings, and that work has made the realities of the barriers young people face incredibly clear to me. The young people I represent are often among the most vulnerable, and navigating this process only adds to the challenges they are already facing. My hope is that today helps deepen your understanding of those realities as well, not just in terms of abortion access, but access to essential health care more broadly. Thank you to our panelists who have traveled from all over the country to be here today, especially given the crazy things happening in airports recently. We are incredibly fortunate to have a group of speakers who bring expertise from the courts, clinics, advocacy organizations, and lived experience to help us explore the legal landscape, the medical realities, and the human consequences of restrictions on care for young people. I am deeply grateful for the support of our incredible director, Jeffy Hill, who allowed me to take this idea and run with it. I also want to take a moment to thank our program manager, Natalie Jamiola, for leading our outreach and promotional efforts, and to our incomparable administrative assistant, Alita Cowan, who handled all of the details and logistics that made today possible. This event truly would not have come together without you. And finally, thank you all for being here and on Zoom and in person. And with that said, I will now turn it over to Jesse to kick off our first panel.
Thank you. Is this mic working? Yeah, you can hear me okay? Okay, is that good?
Just speak directly into it.
Okay, is this good? That's better, huh? Yeah, okay, great. Thank you, thanks. So I'm here to moderate our first panel. Our first panel is actually entirely remote on Zoom. It was not initially planned that way, but because of various, factors such as TSA, the TSA shutdown and weather and so on, we have ended up having an entirely Zoom panel. So I don't know, are they, I wanted to go ahead and introduce our panelists, and then I'll say a little bit about the topic of our first panel before we get started with the discussion. But this first panel is entitled "Who Decides When Parental Rights Collide with Youth Bodily Autonomy?" So do we have our panel? Can we see them, our panelists? Oh, yay, there we are. Okay, great. Hello. So I'm going to introduce our panelists in the order in which they're going to kind of kick off their remarks. Our first panelist is Naomi Kahn. She is the Justice Anthony M. Kennedy Distinguished Professor of Law and the Armistead M. Doby Professor of Law at the University of Virginia. Naomi Kahn is an expert in family law, trusts and estates, feminist jurisprudence, reproductive technology, and aging in the law. Prior to joining the UVA faculty in 2020, she taught at George Washington Law School, where she twice served as associate dean. She's also the co-director of UVA Law's Family Law Center. And she's also the co-author of casebooks in family law, trusts and estates. She's written several monographs, numerous articles at the intersection of all of these areas, too many to name. So thank you for being here.
Thank you.
Thank you. And actually, she's sort of has two co-presenters with her in spirit. She's going to be talking about some research that she's worked on with Mary Ziegler, who is the Martin Luther King Jr. Professor of Law at UC Davis, and Maxine Eichner, who is the Graham Keenan Distinguished Professor of Law at UNC Chapel Hill. Then our next panelist is Professor Courtney Joslin. She is the Distinguished Professor of Law at UC Davis School of Law. She teaches constitutional law, employment discrimination, family law, sexuality, gender in the law. She's a leading expert in family and relationship recognition with a focus on same-sex and unmarried couples. Her scholarship has appeared in leading law reviews, including the California Law Review, Columbia Law Review, and NYU Law Review. And she's the co-author of two popular textbooks, and her commentary has appeared in many places, including the Washington Post and the Los Angeles Times. Our next speaker will be Laura Portuondo. Professor Portuondo is an assistant professor at the University of Houston Law Center. She's a constitutional law scholar with expertise on reproductive rights and justice, gender equality, and the First Amendment. Her scholarship addresses tensions between the First and 14th Amendment and offers novel theories for reconciling them. Her work has been featured in the Duke Law Journal, the UCLA Law Review, the Journal of Law and Religion, and I think has a forthcoming piece in the Yale Law Journal as well. She received her BA in English summa cum laude with distinction from Yale College and her JD from Yale Law School. She's clerked for the Honorable Robert A. Katzman of the U.S. Court of Appeals for the Second Circuit and the Honorable Jed Rakoff of the U.S. District Court for the Southern District of New York, and has worked at the Center for Reproductive Rights. And then our fourth speaker is Solange Maldonado. She is the Eleanor Bontecu Professor of Law at Seton Hall Law, where she writes and teaches in family law, gender, race, and their intersections. She's the author of The Architecture of Desire, How the Law Shapes Interracial Intimacy and Perpetuates Inequality, and the co-editor of two casebooks. She is an American Bar Foundation Fellow and Associate Reporter for the American Law Institute's Restatement of the Law, Children and the Law. She's going to talk a little bit about that today. And she serves on the editorial board of the American Bar Association's Family Law Quarterly, and on the board of trustees of New Jersey LEAP, a college access program for students from underserved communities. So this is our wonderful lineup for this first panel. So what, like I said, it's entitled Who Decides When Parental Rights Collide with Youth Bodily Autonomy? But what we're aiming to do with this initial panel is really to lay out some very broad themes that we hope will resonate throughout the other panels today. So we're kind of zooming out, not focusing on one specific substantive area, but kind of thinking about parental rights and the law more generally. So not just with respect to reproductive health care, gender affirming care, but also how parental rights may touch on other areas of the law, as we'll discuss soon. So I'm going to kick it off first. Oh, wait, I'm supposed to tell also Zoom attendees that you should put questions in the chat. So someone will be monitoring the chat, and we will get to your questions after the panelists have had some chance to discuss. Okay. So I'm going to start off with an initial question for Naomi, for Professor Khan. So earlier this month, as some of you may know, the U.S. Supreme Court issued a per curiam ruling in Mirabelli v. Bonta, essentially blocking a state law that required teachers to use students' preferred pronouns while the students were at school, and not to disclose the students' gender identities to their parents. So that was the state law, and then the Supreme Court blocked that law. The court said this law likely violated both the parent's religious freedom and the parent's substantive due process rights to direct the upbringing of their children. So Professor Kahn, you with your co-authors, Mary Ziegler and Maxine Eichner, have been writing quite a bit about parents' rights. You've argued that parents' rights claims often act as a sort of Trojan horse for other interests. Could you kind of tell us a little bit about your arguments there and maybe a bit about how you see Mirabelli fitting into this picture?
Thanks so much. And I'm assuming you can hear me?
Yes, we can.
Great.
And to tell us to advance your slides.
Okay, that's great. And I do have some slides, so thank you. Yes, and I see they're about to start. So let me just add more thank yous. I'm delighted to be here, albeit virtually. Mary and Max send their apologies, but I want to emphasize, as Professor Hill has already said, that I'm talking about joint work that the three of us have done. And I also, before I answer your wonderful question, I just want to thank you and Katie and Alita and everyone else for all of the work to make this happen. There's been so much behind the scenes with so many last minute changes. Thank you. Okay, so let's go to the second slide, and I'm going to start with, as Professor Hill just mentioned, with Mirabelli, in which the Supreme Court preliminarily ruled on the issue of outing LGBTQ identifying students to parents at schools. And then I'll come back in a minute to Mahmoud. So the headlines, next slide, were straightforward. Court sides with parents in dispute. This is March 2nd headline from SCOTUS blog. Court sides with parents in dispute over California policies on transgender students. And this case, Mirabelli, I'm going to talk more about these parental rights issues, but it builds on Mahmoud, which the Supreme Court decided last year, in which the court also sided with parents in a full opinion rather than the per curiam at issue in Mirabelli. And in Mahmoud, the court relied on parents' freedom of religion claims to say that those claims were violated when their elementary school children were read books showing gay marriage and transgender children in a positive light. So that was Mahmoud. After Mahmoud, it wasn't a surprise that the court saw the California school district's policy in Mirabelli as a burden. Next slide. But the court went further in Mirabelli, holding that the forced outing law violated the due process rights of parents without even considering religious objections. Mahmoud was firmly grounded in First Amendment religion rights. Mirabelli was grounded in First Amendment as well as in 14th Amendment substantive due process rights of parents. Right, another headline: U.S. Supreme Court delivers historic groundbreaking. Right, this case is hailed as a victory for parents' rights. Next slide, please. As Max, Mary, and I argue, however, the truth about parental rights is much more complicated. The court, in each of these cases, in invoking our nation's constitutional history and tradition, has dove right into a growing conflict about what parents' rights mean. And in doing so, it interpreted those rights in a far more absolute way than courts, from the Supreme Court on down, have done in the past, in a manner that we label, as you can see on the slide, parental rights absolutism. The court suggests that it's parental rights that will override even potential children's interests in these cases. And what Max, Mary, and I argue is that the court fundamentally misunderstands our nation's history and tradition. And as we know through this conference, it's children who are going to be the ones to pay the price. Next slide. Stepping back, The court did appear to be building on a longstanding presumption that parents act in their children's best interest to promote their well-being. Next slide. And that's a principle that underlies the restatement, which I know Professor Maldonado will discuss later. It also undermines other cases. Slide 8. But next slide. We've written a number of articles in which we show 2 points. First, that notwithstanding the strength of the presumption that parents act in their children's best interests and promote their well-being, but parental rights have always been subjected to some limits. Perhaps the most obvious one is the family regulation, child abuse, and neglect system. So that's the first point. And second point we've made that I know others will discuss is that this vision of parental rights does not extend to all parents. So our argument is that the Supreme Court's interpretation of the rights of parental history is instead building on a far more recent history defined by conservative social movements since the 1970s. Next slide. They claim the mantle of parental rights, long recognized by courts, but instead of actually promoting parental autonomy while balancing children's well-being and government's legitimate interests, the classic triad of parent-child state, these laws use this rhetoric as a way to divert attention from what these laws are really doing, from how these laws disguise the potential harms to children's well-beings and to societal interests that these laws threaten. Instead, many of these laws don't even protect parental autonomy. Next slide. We've developed a test to determine what laws really are promoting, when laws really do promote parental rights and children's well-being, and when they're promoting this, when they're just promoting rhetoric and parental rights absolutism. I may be able to get to that later in the questions. But I just want to stop here and say that what we're seeing, what we show in this series of articles is that this parental rights absolutism is being used as a way, as Professor Hill mentioned, as a Trojan horse, as a shoehorn to bring in all kinds of other interests under the meme of protecting parents, but ultimately it's the children who will be facing the consequences as well as the parents who disagree with these policies. Thank you. Next slide. Hope that answers the question.
Thank you. Yes, that's great. Yes, thank you so much. And I think that really sets us up well, actually, for Professor Joslin, who is going to share some thoughts with us. I think, Professor Joslin, you approach the same set of issues from the perspective of invoking children's best interests. So this is a dominant theme, of course, in family law doctrine. So maybe you could talk to us a little bit about how the concept of children's best interests have come to play a similar role to parents' rights claims that Professor Khan just talked about.
Great. Thanks. Is my sound okay?
Yes.
Great.
Yeah.
Excellent. Well, I'll start also by just thanking Professor Hill, Katie, all of the student organizers and staff who made this conference happen. I'm really thrilled to be here. And I'll start actually my response by establishing as a baseline my profound agreement with what I take to be a core goal of this conversation, that being that the law should promote children's welfare and well-being, including with regard to their reproductive and other forms of healthcare. And with that goal in mind, my answer to the question that you posed is in some ways a cautionary tale. When working towards that end, I want to suggest that people should be cautious and careful when presented with arguments that claim to be lifting up the voices of children, their needs, and their rights. And in some ways, I think my remarks are maybe the inverse of what Professor Khan has written about. Naomi, Mary, and Max have shown how invocations of parental rights rhetoric have been leveraged to undermine rather than to further equality and liberty. And in my short remarks today, I want to identify a similar rhetorical device that has been used in similar ways. And my focus here is on the strategic use of children's welfare, children's interests, and children's rights. And I deliberately use all of those different phrases. They are different phrases. They have different meanings, but often all of them are invoked, sometimes interchangeably and often in very slippery ways. And so in my few minutes, I first want to identify some of the many examples in which we have seen this rhetorical device be used. And then I'll close by offering some suggestions for moving forward. Okay, slide 2, please. So I'll start with the present. Specific focus of this conference is on minors' access to gender-affirming care. And this is an example of a campaign in which we have seen this very rhetorical device at work, right? So in banning access to gender-affirming cares for minors, Tennessee legislators expressly invoked the rhetoric of children's interests and their well-being. So you can see it there in the first legislative finding. The legislators declare that they must take this action to, quote, protect the health and welfare of minors. And this strategic utilization of the rhetoric of children's interests and rights is not new. And indeed, I think particularly in the context of struggles for LGBTQ equality, claims centering the rights and interests of children have long been invoked to justify the denial of equal rights and liberties. So slide 3. So here, for example, is a brochure used in 1977 as part of Anita Bryant's Save Our Children campaign. That was a campaign to repeal a municipal ordinance that prohibited discrimination against lesbian, gay, and bisexual people. And this campaign invoked parental rights rhetoric, as Naomi has shown elsewhere, but it also expressly invoked the rhetoric, not just of children's interests and well-being, but indeed used the language of children's rights too. So you can see that the title is Save Our Children, but you can also see on the right, in joining the movement to repeal these non-discrimination protections, people are declaring that they are for children's rights. And these are, again, are not isolated examples. Next slide. Children's rights and children's interests featured prominently, for example, in the 2008 campaign in California to pass a state constitutional amendment to end access to same-sex marriage in California. And you can see here again, the key rhetorical argument in favor of Prop 8 was that it was necessary in order to protect children. Next slide. So we can see that this is a long used strategy. And now I want to loop back to the present and identify another ongoing campaign. This one was announced earlier this year in January 2026, and it is a campaign to overturn Obergefell and the right to same-sex marriage. And this campaign is very expressly and intentionally framed around the rhetoric of children's rights and children's interests. So here, Katie Faust, who is the founder and director of the organization Them Before Us that is leading this new campaign. And she describes this campaign as an expressly children's first campaign that prioritizes children's rights. Next slide. And to be clear, this campaign seeks not only to end same-sex couples' access to marriage, but it also seeks to roll back other rights and protections for LGBTQ people and their families. So they are also seeking to roll back laws and policies that recognize and protect LGBTQ people's relationship with their children, that reflect and affirm these relationships through other official documents like birth certificates, that affect their access to fertility care, to form families, that affect their right to health insurance to cover this fertility care. So like with invocations to parental rights, invocations to children's interests and their rights have really widespread and powerful appeal. We were all children. Many of us have children. We all care about children. Nobody wants to be associated with a position that purportedly harms children. And I think for these and other reasons, these claims really resonate broadly and deeply. But as advocates, as lawmakers, as lawyers, as others working to promote the welfare and well-being of children, I think as is true with anything these days, when these claims are made, caution and care is warranted. And among other things, I want to suggest that one should carefully examine the evidence that is mustered to support these claims. One should consider whether the evidence reflects the experiences of all children or just a subset of children. And one should identify and consider the rights and interests of other relevant stakeholders. And so I know I'm going long, but just I'll take a couple of them in order, starting with the first, with an evaluation of the evidentiary support. This seems obvious, but it's actually quite easy to forget, I think, because again, claims about harms to children have really strong pull and resonance. Next slide. So here, for example, is a 2007 decision from the New York State High Court upholding their ban on same-sex marriage based on concerns about harms to children. And here, the court did not cite any evidence. It was enough, the court said. The legislature could have thought that limiting marriage to a man and a woman was better for children. Something the court continued was suggested by intuition and experience. Next slide. But I suggest that, again, when making or supporting policies, especially ones that have the potential to reverse equal liberty gains, one should be wary of claims grounded merely in intuition. And further, even when there is empirical support for the claim, it's also important to consider whether the evidence reflects the interests and welfare of all children, or whether, in contrast, it reflects merely a subset of children. Next slide. And then finally, just turning to the last point, typically when these claims involving allegations of harm to children and children's interests are invoked, there are also other people and other interests at stake. And so here, returning to the example of same-sex marriage, again, certainly children's interests ought to be considered when they are impacted. But again, there are often other individuals whose rights and interests are at stake. And with regard to marriage, that would include, of course, the rights and interests of the adults who are seeking to marry, and their interests ought to be a part of that conversation. I think as Naomi has shown elsewhere, sometimes the rhetoric of parental rights is invoked for the purpose of obscuring other considerations, and that is happening in this context as well. And so this is the campaign that I mentioned earlier. And here, that goal of obscuring other interests is being stated quite expressly, right? They are declaring that children's rights are greater than. Real progress, they state, means putting children's needs ahead of adult desires. And I think this should look familiar to those of you who work in the context of abortion care, which is another area in which we have seen that kind of obscuring of interest happening as well. Last slide. So I'll end where I began, which is, one more, which is just to remind us that it is a generally shared goal of many, if not most people, to support laws and policies that promote the interests and rights of children. But we ought not reflectively to support any position that claims to further that end. And instead, as with any policy position, care and caution is warranted. And that's it for me.
Thank you so much. Yeah, fantastic. Well, I think we are going to move on to Professor Portuondo next. And I think maybe doesn't have slides, I believe, right?
No slides.
No slides, great. And so Professor Portuondo, I know, we talked and Professor Khan talked a little bit about the fact that these parental rights claims are sometimes joined with religious freedom claims in these cases, and much of your work has focused on constitutional doctrine with respect to both religious freedom and substantive due process. And I know lately you've been thinking about the role of institutions too in mediating religious freedom and parental rights claims. So can you talk a little bit about how institutions like foster care organizations, for example, figure into this mix, and why do they matter?
Yeah, so thanks so much for having me. I'm sorry I can't be there. I'm based in Houston. So as you may know, Houston is ground zero for TSA right now. So unfortunately, I'm remote, but I'm really happy to be here. And I think this is a great conference. I'm really happy to see these issues of sort of trans care, gender affirming care, and abortion and reproductive rights all brought together, because I think they're all so closely related. So yeah, I mean, I think my comments here tie in well to both Naomi and Courtney's comments, and specifically this idea of, I think Professor Jocelyn is right that there's an appeal to these sort of ideas of children's rights, protecting children can be used as a way to roll back sort of equality and liberty protections. I want to focus on another kind of appeal that I think these parental rights arguments have. Sort of the inverse, the parental rights arguments, right? I think there's something about these arguments which has been true of religious liberty arguments for a long time, which is the claim is sort of an appealing one of withdrawal from sort of totalitarian regulation by the state, right? These are just parents who might have different beliefs from the majority, and they shouldn't be sort of forced to conform in a way. They just want to exempt their kids. They're asking for modest relief. They're asking for retreat into a realm of private family life that the state shall not enter into, which I think has some political appeal. So what I've been doing some research about recently, though, is how these sort of claims for withdrawal, these parental privacy or religious liberty claims, are in fact intersecting with public institutions in ways that are generating harms that go well beyond a single family. So specifically, religious parents are increasingly using parental rights claims not just to restrict the rights of their own children, but to reshape public institutions that are designed to serve all children. And so what this does is it actually amplifies the harms of parental rights claims by making those public institutions less safe for all kids, and actually serves to reshape public policy more broadly that affects all of us. So this pattern of individual liberty claims being leveraged to control unrelated third parties and reshape public policy is nothing new in the religious liberty context. In one recent case, for example, a group of physicians tried to use their religious objections to abortion to pull medication abortion off of the market entirely, something that would, of course, affect millions of pregnant people who have nothing to do with these particular doctors or not receiving care from these physicians. And in a context more related to today's themes, individual parents with religious objections to contraception have brought statutory religious liberty claims that would make it harder for all teenagers to access contraceptives. So this move of leveraging a purportedly personal or private religious claim to restrict the rights of the broader public and reshape public policy is a familiar pattern and not new from the religious liberty context. What I think is new, or at least the way this intersects with parental and religious right claims, is how these fused sort of parental and religious liberty right claims are reshaping those child-serving government institutions in ways that affect vulnerable children beyond any one family. So take Mahmoud, which I think we touched on briefly. Professor Khan mentioned it, right? This was the case where parents were seeking exemptions from an LGBTQ inclusive curriculum, right? They said, we don't want our kids exposed to these books that are being normal about LGBTQ people. And so on the surface, that sounds like it's just a request that's really only going to affect the children of those parents seeking an exemption. Again, we should be worried about those kids too. But it's also important to look at what these exemptions do to the public school as an institution. So first, as these schools pointed out, and part of why they didn't want to provide these exemptions, administering these individualized exemptions is so costly and complicated that many schools will simply drop this LGBTQ inclusive curriculum altogether. And so what this means is that every child in these schools ends up with a narrower, more exclusionary education, including kids whose parents never objected to anything, right, and might be queer families themselves. So second, right, even if we assume that these exemptions are workable, schools can do it, shuffling a bunch of kids out of the room anytime an LGBTQ book is pulled off the shelf has an unmistakably stigmatizing message for LGBTQ children and their families. So in this way, this like purportedly narrow or private individual exemption actually generates harms well beyond the single family by reshaping what public schools look like for everyone. So another example comes from a recent Ninth Circuit case. This was actually just a pure religious liberty claim, though I think it intersects with parental rights claims in an interesting way. It's this case called Bates versus Paksharet. I don't know if I'm saying that right. In that case, Oregon had a policy requiring prospective adoptive parents to agree that they would affirm a child's identity. So any identity, right? Their racial identity, their religious identity, LGBTQ identity is on the list of things that parents are required to affirm if they want to adopt a child. So a religious plaintiffs challenged that policy, arguing it violated her religious liberty. So, in other words, what she was saying was that she should be able to adopt a child from the public welfare from the public foster care system without saying that she would affirm that child's queer identity. So you can think about the horrible situation this could create for an incredibly vulnerable child. Despite this, the Ninth Circuit ruled in her favor. They said she did have an entitlement to be exempted from this requirement. And so the practical result of this sort of private exemption is actually to make LGBTQ children in Oregon's foster care system incredibly vulnerable, right? They can no longer count on being protected from discrimination when they're placed in a home. They might be placed in a home of somebody who objects fundamentally to who they are. And once they're placed in that home, of course, the state can't really come in and protect them anymore because now they're protected by these parental rights claims. So again, one individual's religious liberty claim is reshaping, in some ways, an entire public child welfare system in ways that are putting some of the most vulnerable children in our society, LGBTQ children, vastly overrepresented in the foster care system, at risk. And so I think with these examples in mind, going forward, I think it's really important to track how these parental rights claims, often intersecting with religious liberty claims, which purport to be about individual liberty within the family or the home, are in fact fundamentally fights about public institutions, who's controlling them and who has access to them. Understanding how these fights are not just about children within one family, but about these public institutions doesn't just more fully illuminate the stakes and the harms of these claims. I think it also helps to highlight and legitimate the democratic interests on the other side of these liberty claims. These claims are not just a claim to withdraw from public life, but to reshape public life. It becomes clear how the public has a right to push back against these claims. It's not some totalitarian impulse, but a healthy desire for democratic control over vital questions of how all children are raised and protected in our society. And so with that, I'll leave it back to you, Jesse.
Thank you, Laura. So yeah, that's fascinating. And also I just want to mention you had mentioned the Oregon case, it'll probably come up later today, but there is a legislation being considered in Ohio that would basically say that no state actor could take into account like a person's unwillingness to affirm a minor's gender in custody and foster care and so on, those types of decisions. So would essentially institutionalize that Ninth Circuit approach. So again, lots of connections here. I want to shift over now to Professor Maldonado. So you participated, as I mentioned in my introduction of you, in drafting the restatement of the law, Children in the Law. And in that process, you had the task of actually trying to balance the interests of parents with the interests of children, and identifying coherent legal principles that could attract a consensus among a diverse group of legal scholars and professionals. I am sure that was no easy task. So could you share a little bit about that experience and what you learned? And maybe you could say a little bit also for folks here who are not attorneys, what the restatement of the law is.
Yeah. So thank you so much. I just, I wish I had been able to get there in person. I've actually been to other conferences at Case Western, and I've just been welcomed. So but thank you, Jesse, Katie, Alita, and everyone else who made this panel happen. So I will spend a minute just explaining what a restatement is and why it might be relevant to conversations about parental rights and minors' bodily autonomy. Now, sort of just like big picture, most of our understanding of the law and parental rights is really constitutional law and common law, meaning, the law that is developed and articulated by judges in the course of deciding specific cases, as we've seen, we've talked about today. But there's so many cases, and obviously when we get to looking at, state cases as well, so many jurisdictions, that these principles are at times unclear and sometimes even incoherent. So the goal of restatement, I mean, it's secondary authority, where the American Law Institute, invites law professors to basically draft, these clear formulations of common law, constitutional law, and its elements. And restatements are supposed to be a collaborative process with several layers. So at the first layer, you have the reporters, typically law professors, who research the entire field. So you can imagine, hours and hundreds of hours of work. And then we draft what we believe is a clear formulation of the law with regard to a particular issue. Basically, this black letter rule. However, unlike a judge's pronouncement of the law, the restatement rules and their comments and the illustrations that basically flesh out this rule have to be approved by its membership, members of the American Law Institute, who will vote on these sections. And the ALI, American Law Institute, has approximately 3,500 to 4,000 members, roughly one-third legal academics, one-third judges, one-third practicing lawyers. And although not everyone is going to show up to the annual meeting to vote on a particular subject, even if you only have a few hundred members show up, objections from a few people, especially if they are judges, can really force the reporters almost like back to the drawing board, or requiring us to edit or to remove, certain phrases, certain explanatory materials, in order to ensure that the project will actually be approved and will be relied upon by the courts and practicing lawyers across the country. So I want to make sure sort of that we understand that the restatement of children of the law recognizes the well-established legal principle that Professor Khan and Professor Jocelyn and Professor Portundo have already talked about, which is that, that it's well established that parents have a fundamental liberty interest in the care, custody, and upbringing of their children. And so that means that they have considerable authority and responsibility, duty, to make decisions about their children's medical care, for our purposes today, but also education, relationships with third parties, supervision, etc., without unjustified governmental interference. Now, the restatement explains that this deference to parental decision typically serves children's best interest. And I want to emphasize here, typically, because obviously there are going to be many exceptions, but that this deference to parental authority will typically help, will further children's interests and broader societal interest in family integrity and in pluralism. So in theory, deference to parental rights is supposed to protect families of color, poor families, religious minorities, LGBTQ families, sort of our most vulnerable families, from unwarranted government intervention. But the restatement recognizes, that parental rights are not absolute and that the state may need to intervene when necessary to protect children from harm to their mental or physical health. So this need to balance parental autonomy, children's interests, and states' interests was present in virtually every section of the restatement, but certainly in the context of medical decision-making for children and youth. And so I want to share here just two very brief examples of the type of compromises that we had to make. So I drafted this section. Can we have the second slide, please? Thank you. So this section, I drafted it back in probably 2017, but by the time it got to the American Law Institute's, sort of general membership, it was, a year later. And as you see, this section just really states a very well-established principle that a parent or guardian has broad authority to make medical decisions for a child. But then it clearly tries to limit that parental authority by clarifying that a parent does not have the authority to consent to medical procedures or treatment that pose no health benefit to the child and which pose a substantial risk of serious harm to the child's physical and mental health, right? So we don't want parents consenting to medical treatments that actually aren't going to benefit children and could actually hurt them. And then here's where the controversy sort of came in. Subsection C states that a parent does not have the authority to consent to medical procedures or treatments that impinge on the child's constitutional right to bodily integrity or reproductive privacy. Now, you're probably wondering, why is bodily integrity crossed out? And the reason it's crossed out is because although, as I said, restatements have several layers, and it goes through each section. Once it's drafted, we get feedback from our co-reporters. Then we get feedback from our advisors and a members consultative group. And Professor Khan was one of our advisors who gave us great feedback. And then that advisory group is comprised of social scientists, legal scholars, judges, practicing lawyers. And then it goes to another layer, the leadership of the ALI, the ALI Council, and we got, no pushback on this section because it's pretty well established legal principle. And then we got to the general membership. And at that point, here we are, it's a ballroom of maybe, 500 people were there, and they've read, the project. And we, a couple of, one of them was certainly a judge, expressed objections to the term bodily integrity. And he said, look, if you keep that language in there, our state, my state, I won't say which state it was, although I remember which state, he said this state would not use the restatement. And then another judge from another jurisdiction, another conservative state, said that his state also would not use the restatement. They would not rely on it. They would not cite to it as long as we had this language in. So had to take it out. And so the result of this change is that the restatement doesn't actually take a position on whether a parent can consent to a medical procedure or treatment that impinges on a child's bodily integrity. Now, you may think, well, that's not so bad because we still have the language of reproductive privacy, right? So a parent cannot cannot consent to a treatment that will impinge on the child's right to reproductive privacy. But it turns out that reproductive privacy is not sufficiently broad or was not interpreted by these ALI members as being sufficiently broad to protect children from certain types of procedures. And so here I just want to give you, sort of explain why this might matter. So in the restatement, we had a comment and an example, sort of fleshing out when a parent would lack authority to make healthcare decisions for a child. And this example was based from an actual case from Virginia. And so here we had a child who was born with a penis and a small vaginal opening. So, the term that the court uses, an intersex child. Now, the child was healthy, and there were no health risks to the child resulting from having both, penis and a vagina. However, the child's doctors, now this was a young child, a toddler, when the doctors made this recommendation, the doctors recommended surgery, in this case, multiple surgeries, to remove the male genitalia, to remove the penis, and make the child's anatomy fit a female gender assignment. The only reason for the surgery was so that the child would appear, quote unquote, normal. Now, the question was whether the parents have the legal authority to consent to the surgery. Now, the restatement concluded that the parents do not have the authority to consent to this surgery because it offered no medical benefit to the child, and as a complicated surgical procedure or multiple procedures, like any surgery, it did pose a risk of harm to the child's physical and mental health, and it impinged on the child's fundamental right to bodily integrity, as far as we were concerned. But since we had to take this section out on bodily integrity, this means that the section that was ultimately approved and which will actually be in print, it takes forever once a project is approved to actually be in print, it will actually be in print later this year, doesn't really take a position on this, on protecting children from that type of procedure. Just very briefly, a second example, we faced a similar challenge when we tried to include a section on minors' rights to access gender-affirming care. So after reading all the cases, the statutes, reports, the World Health Professional Organizations Association for Transgender Health WPATH report, and all the relevant articles on gender-affirming care, I drafted a very short section that addressed parents' rights to consent to gender-affirming care for a minor when the minor seeks it, and it's recommended by the minor's healthcare providers. Now, I drafted this section right after the Attorney General of Texas issued an opinion concluding that providing gender-affirming care to a minor may constitute child abuse. And the governor of Texas have directed child protection agencies to investigate parents who sought gender-affirming care for their children, to investigate them for child abuse. Now, the restatement section that I drafted acknowledged the court's disagreement. I mean, at the time, there was only one court that actually, the Sixth Circuit, that disagreed that parents might have a due process right to provide their children with gender-affirming care. So the restatement acknowledged this sort of ongoing debate, but it concluded that a parent who provides a child with gender-affirming care consistent with accepted medical standards does not commit child abuse. So we thought this was a pretty non-controversial statement. Well, I received great feedback from our advisors, but then we got some pushback from the ALI Council, the leadership, and it became apparent that the section was unlikely to be approved. So we actually never sent it up to the ALI membership for a vote because we determined that it was unlikely to be approved and that putting it forward might jeopardize the likelihood that other sections of the project would be approved. So these are just two examples of the challenges of trying to balance sort of parental autonomy, the interests of children when they are in tension, but also the challenges of articulating what we believe are clear legal principles when parental decisions and children's interests are aligned, but the state is opposed to that, to sort of, whatever it is that parents had agreed, had decided was in the child's best interest. In this case, specifically gender affirming care. So I'll stop. I think I'll stop there.
Thank you. Yeah, that's a really fascinating inside look at the process. We don't normally get to hear about that. So what I want to do now is I'm going to transition to asking like a few questions that I have prepared for the panelists. Whoever wants to kind of jump in, I think that should work okay if you want to unmute yourselves to answer. And then we'll save a little time at the end here. We go till 10:15, so we'll save the last 10-15 minutes for audience questions. So I guess my first question is just sort of about the fact that parental rights are really kind of all the rage at the moment, as we can see from some of the remarks. They technically have a very long constitutional history, right? Professor Khan touched on this, but they've really just gained in prominence recently, and of course some of this is probably, as some folks suggested, because they align, parental rights ideas can align with particular conservative political agendas. But also, advocates on the progressive side are also trying to use parental rights claims as well in the courts. So I guess, does anybody have thoughts about just sort of why are these claims so attractive and kind of salient in this political moment that we're in?
I mean, I can say, I mentioned in my remarks as I was speaking about children's rights that, I think one of the reasons why that rhetoric has such pull is because it does resonate with all of us. I think it resonates with all of us across political persuasions. Again, we all care about children. We all feel like we have some knowledge about children and children's rights because we ourselves were children. Again, many of us have children. And I think there's a natural instinct to not want to oppose an argument that purports to be in furtherance of children's rights. And I think there's something similar happening with parental rights. Again, I think in theory, it is something that people support across political lines, that we as if one is a parent, one supports the right to make decisions for their children. And so, as an abstract concept, I think it is one that is appealing to people across political persuasions. And I think the challenge, as I suggested in my remarks, is to make sure that as one is evaluating those claims which have such power and resonance, that one is quite careful to consider not just the claims of the parents before the court or at issue in the particular case, but also to consider the ways in which the interests and rights of other people not currently in view might be impacted by those claims, and to appropriately evaluate and try to balance competing interests which might be at stake, which are typically at stake when we're thinking about a parental rights claim. There typically are other people, other interests that are going to be impacted by the resolution of that dispute.
Others have thoughts?
I mean, I think I can add from so I think for the reasons that Professor Jocelyn said, right, this is why this is an appealing tool, I think, for sort of less democratic conservative legal movement to say, right, here's a way to sort of instantiate these values that doesn't depend on democracy, right? We can appeal to these sort of broad values of children's rights or well-being and parental liberty to sort of achieve policy goals that they can't really sometimes get, right, at least in blue states through democratic processes. But I think, right, why are people on the left using these claims? Why are parents of trans kids trying to, provide them with gender-affirming care bringing these claims? I think it's also partially a real narrowing of the scope of equality claims under the Constitution right now. And the narrowing of sort of the traditional home of these sort of gender-related liberty and equality claims, right? So we have these really narrow equality rulings coming out in cases like Skirmetti saying, oh, a ban on gender-affirming care has nothing to do with transgender people at all, fortunately. Right? And you have a case like Dobbs saying, well, actually, the scope of liberty is not broad enough to include essentially kinds of conduct that defy traditional gender norms, and increasingly it's looking that way for other sort of gay rights holdings too, right? So I think the parental liberty claims, particularly when they're intersecting with the religious liberty claims, is just sort of hooking on to a thread of constitutional jurisprudence that seems to be more robust and more resistant, I think, to the clawback that's happening right now in so many spaces that are explicitly about gender-related liberty, gender-related equality. So I think that's why people are bringing those claims from the left. And I think as a strategic matter, it makes sense, even if we might want to have a broader discussion about resisting these in a political sphere. What are the best arguments for that?
I'm happy to jump in, and I completely agree with what both Professors Portuondo and Jocelyn have said. There is, if you look at public opinion polls, there is such widespread public support for parental rights, even in the situation in Mirabelli, for requiring school districts to inform parents about their children's exploration of gender identity. In the time after Roe, there was support for parental permission / notification with respect to minors obtaining abortions. There's just it's broad support, so broadly appealing in the public, and so that then provides legislators and courts, particularly legislators, with reasons to go forward with these laws, like the one that Professor Hill just talked about. And also, just to build on what both people have just said about the left, there's also a claim in the family regulation, child abuse, and neglect system that there needs to be more protection, and this is coming from the left, more protection for parental rights in those situations because of the disproportionate impact on families of color. And so there is the claim of parental rights is useful for so many reasons, and yet it can hide so much of what else is going on.
Yeah, thank you for bringing that into the picture as well. I think, unless anybody else wanted to jump in, or Professor Maldonado, I think
It looks like, I'm sorry, it looks like she might want to.
Yeah, I just wanted to just to add that, that when I mentioned just that the restatement, position was very strong on parental rights, and one issue that we really debated had to do with corporal punishment. Parents, the parental privilege to physically discipline children, and most academics, virtual academics, believe that all the science shows that physical discipline of children it can be very harmful, and it is never helpful. However, every single state recognizes a parent's privilege to physically discipline a child. And I remember that, at one of these meetings, there was someone who said, we need the restatement must continue to recognize this parental privilege, because if not, families of color and poor families are going to find themselves losing their children even more than they do now. And so, so parental rights, we're talking about parental rights in the context of medical decision making, today, but keep in mind that parental rights, sort of just are, very broad. And so they include parents' rights to make decisions as to how to discipline their children, how to supervise their children. So it's almost like, can we have one without the other? Because we want to recognize parent autonomy in certain cases, but in other cases we want to limit it. But the problem is, if we limit it, now that means that we're giving a lot of power to the state. And the way that the way uses its power is, definitely is not equitable, and disadvantages, the most vulnerable families.
Thank you. Yeah, excellent. And that actually provides a really great transition into the next question that I was going to ask, which is, I think so somebody had put up the kind of idea, a slide on the idea of the sort of triad here, parent, child, state. But I think what seems to be getting lost sometimes in the cases recently around parental rights is that sometimes they involve situations where the parent's interests are aligned with the child's interests, like for parents seeking gender affirming care for their children, for example. And sometimes they involve situations where the parents' interests are in conflict with the child's interests. So, like the Mirabelli case, where the parents, wanted the schools to out their children to them. And so I guess one question would be like, how should this distinction matter when courts are deciding parental rights claims, and what should they be saying about that?
So I think I can start. This is a really hard question because it really depends, right? And so we had to deal with this, or in the restatement, in the context, in various contexts. So, in the context of when a child's life is at issue, for example, when the child and parent, let's say for religious reasons, they agreed to refuse life-saving treatment for the child. Well, the parents' interest, the parents' decision, and the children's decision are aligned, but those cases are really hard. And so the position that we took is that, well, if the child's life is at risk, then the state can intervene in order to protect the child, even if the parent's decision and the child's interest might seem to be aligned. But when the child's life is at risk, it's hard to say that they are aligned. A very, a big issue was when parents, and when the parent and the child refuses conventional medical treatment in favor of spiritual treatment, right? So here you see, almost always these cases involve sort of spiritual reasons why they refuse the medical treatment. So we concluded that the state's interest, in protecting the child has to trump parental authority. However, in cases where the child's life is not at risk and the parents and the child's positions are aligned, then it would seem that in many cases, the state should defer to the parent's decision and the child's assent. So, for example, if a parent consents to gender-affirming care and is recommended by the child's healthcare providers, then, the state should defer to the parents and the child and the medical providers. But where this gets really difficult is how do you know if the parent's decision and the child's interests really are aligned, um, even though the child's stated wishes may align with the parent's decision? So, for example, a parent may pressure a child into into agreeing to conversion therapy, or a child to agree to genital surgery if the child is intersex, or a parent may be pressuring a child into donating a kidney to a sibling. In those cases, we don't want the state to defer to the parents, even though the child seems to agree with the parent, but we would want the state to appoint, the court to appoint a guardian ad litem to represent the child's interests. Also, one area where this is very, very clear, and the restatement actually has, like very clear black letter rule, is in the context of abortion. So parental consent to terminate a minor's pregnancy is not going to be sufficient without the minor's also voluntary agreement. And so we are very concerned that in some cases where it seems that the parent and the child are in agreement, that it's really the parent who's sort of making the decisions and pressuring the child. And so that's why this is it's a very complicated question.
Absolutely. Go ahead.
I want to add briefly that in the Scrimeti case itself, the ban on gender affirming care for minors, my co-author Max Eigner and I were each involved in different briefs in which we raised the parental rights issue, because it was an example where parental rights, if parents wanted this type of care for their children, then it was the state saying, no, you can't get that care. And there are certainly previous cases. The great student free speech case, Tinker versus Des Moines, involved a parent and a child each advocating on behalf of the child's free speech rights in the schoolhouse. So there are certainly plenty of cases where the rights are aligned, and there are, and courts need to hear evidence-based discussions and analysis of just what children's interests might be, of what parents' interests might be, and of the diversity of interests. Because there are conflicts between parents asserting these different rights on behalf of their children. Sometimes the parents are not necessarily promoting children's well-being because they're focused on what we call this parental rights absolutism, and sometimes the interests are in alignment. And so there are also important questions about how we let children speak and how we understand what they say in court.
And maybe just a few more words echoing, I think, things that both Professor Maldonado and Professor Khan said. I would just caution, it's important to remember something that is easy to forget, which is parental rights are not absolute. And by their nature, they require consideration of other interests at stake, including the interests of that child, as well as how, as Professor Fortunato pointed out, it might impact other children and other families. And I guess I would say, where you have cases where the interests of the parent and the child at issue are aligned, that does seem relevant to the consideration of the claim of the parent at stake. Not to say that that always means the court must approve that decision, because there might be other state interests at stake, and the state might take the position that ultimately the decision is contrary to the best interest of the child. But I do think that the fact that the parent and the child claim in a particular case that their interests are aligned is relevant. And likewise, if there isn't alignment, that too is relevant and should be part of the court's consideration in these cases that are sort of by their nature really complicated and very, very fact specific. and don't typically lend themselves to simple answers. And I think we're seeing kind of a flattening of the analysis in these cases, making them appear much more simple than I think they are and should be.
I have many more questions, but I do want to, as we're getting close to time, I do want to give some chance for the audience if there are questions out here for folks, and there might be some online as well. I know there's so, and we have a mic, right? Is somebody gonna oh, great, we have a mic, so please wait for that if you have a question, because obviously we have Zoom presenters and Zoom participants. Okay. Yeah.
Hello. Thank you to our fabulous panelists. I have a couple of questions from our audience members on Zoom. So I will start with one. And it says, it seems to me that some of the pushback against LGBTQ families and individuals is rooted in the old stereotypes about LGBTQ peoples as predators. Though the language around this has changed and evolved into being child-centered. Do any of the panelists have thoughts about this and where we go from here? It just seems to me that slapping the term child-centered on something is one way that the conservative legal movement intends to shut down its opponents.
I'm happy to start. I think the question absolutely identifies something that we have seen, which is that arguments about children and children's best interests have been used for decades as an argument to oppose, as I said, equality and liberty for LGBTQ people. So, back in the 70s, when a lot of the cases involved parents who had recently come out as lesbian or gay and who were in custody disputes with their former different sex partner. In those cases, we saw similar kinds of arguments that the LGBTQ parent should not be awarded custody of their child because if the parent was awarded custody, it would cause harm to the child. I think as the questioner points out, the exact articulation of the harm to children has varied over time. But the fact that claims about children and children's interests are being leveraged as a way, again, to oppose equality and liberty or to roll back equality and liberty are ones that we have continued to see. These are not new arguments. They are old arguments that we're seeing recirculated today. And I guess I would just repeat something I said in my remarks. I mean, it seems to me that one way of responding is to, press those articulating these claims to present evidence to support their claims that this is causing harm to children, and again, to lift up all of the interests that are at stake in these disputes. Yes, of course, interests related to children are important and ought to be considered, but there are other interests at stake in these cases, whether it be about a parent's right to custody of their kids or a parent's right to marry their partner. There are other interests at stake, ones of constitutional magnitude, and those must be considered as well and should not be obscured simply because there might be some claims about children's interests at stake in the case.
Thank you for that. We have a couple more questions unless somebody in the audience has one.
Or did anyone else want to weigh in on that? Okay, sorry. Just want to see if any other panels. Any questions in the audience? Oh, go ahead, Jim. Professor Madigan.
These are super quick, so I'll state them both for Professor Maldonado. With regard to the bodily integrity omission, I wonder if there might be maybe something that's a little more antiseptic as an explanation. I'm not sure it is or not, and that is, it struck me that it might outlaw circumcision of male babies. And I wondered if maybe that might have been one of the causes of pushback. I don't know. So I'd be curious. And then secondly, Professor Khan teased us with a 3-part test to distinguish well-being from BS. And I just wondered if maybe there was a way of very quickly telling us the 3 highlights of that test.
So I can go first very, very quickly. Yes, we did talk about male circumcision because, that was a concern that came up. And the way that we made it, you know, we concluded that a parent could decide to circumcise a male, a child's penis, and that would not actually impinge on the child's bodily integrity, because there is some medical evidence. There's some medical evidence that there is a benefit, you know, in terms of lower risks of HIV, lower risk of infection. And so because there was some medical, you know, testimony that says, yeah, there are some benefits to circumcision, although there are, you know, some clear, you know, sort of objections. But we thought it was because there was some benefit, then parents would still have the authority to make that decision. But when it came to, for example, you know, like intersex surgery on a child, there was no justification for that, and so that's how we made that distinction.
And thank you. I'll just briefly say that we did, Max, Mary, and I do talk about the default rule should be the established rule that we should generally defer to parents because of the assumption that they will be promoting their children's welfare. But then we take three indicators from anti-discrimination law that we think can help in deciding the legitimacy of a law and whether it actually promotes parental rights. Does the law burden historically disfavored groups? Is there a pattern of actions by lawmakers causing harms to the groups burdened by the statute or disfavoring the activity disadvantaged by this statute? And then are there inconsistencies or weaknesses in the justifications for giving parents the decision-making powers? So that's essentially just the three-part test that we articulate, and in one of our articles we apply it to a series of different contexts. But there have to be, I mean, yes, sometimes we do want to protect parents' rights, and there have to be legitimate ways of doing that and of finding the best way to do so. And other times the claim of protecting parental rights, or as Professor Jocelyn said, the claim of protecting children, as we've all been discussing, gee, maybe there's really something, maybe that's really not the goal, even though that's the stated goal.
Do we have any more in the audience? If not, maybe another online. Oh, go ahead up front. Sorry. Wait for the mic if you would.
Thank you so much, everyone. I have a couple of questions that might be veering kind of into the process more than anything, but I am curious about, because throughout all of these conversations, the centering of parents and parents' rights have been at the forefront, and I understand that that is the panel. However, I think that we are really leaving out the voices of kids. And so I am curious, and also like advocate groups who have been working for a long time. So I think about intersex advocate groups, HIV, awareness groups, and also tending to the foundations of adult supremacy that seem to be like largely missing from the conversation, at least in my perspective. So I am curious about like, where is that being centered? Where are the children's voices being centered? And also just like tending to the fact that the foundations of these laws themselves are founded in a power over approach to children.
Yeah, so I agree with you. There's a important like absence of, you know, a way to, or in this panel, we're not talking about children's rights as much. And I think part of that is like because of the way that the doctrine is structured, like children don't really have rights under the Constitution in a way that can be brought up as a way to oppose these parental rights claims, right? And so in some ways, like the doctrine constrains the ways in which children's interests are taken into account in a way that turns it into conversations about, well, like, oh, the state's power to protect children is really the only way that children's rights are protected. But then we see how feeble and malicious sometimes the state can be in asserting claims about what's good for children that does not take into account what children want at all. And so I think a huge problem in this context is this lack of like a good legal vehicle for bringing children's rights, like as described by themselves, into the picture. And so I agree with you that it's like a huge problem. And it's also just in some ways, all my answer is suggesting is it's a doctrinal problem in a lot of ways. Um,
Go ahead, Naomi.
Yeah, and I'll just say there is a parallel children's rights movement. Among other people, Professor Catherine Smith at Washington and Lee has been doing an enormous amount of research and is hoping with two co-authors to do a new constitutional law casebook that essentially takes many of the cases that we read, say, in family law and children law, and approaches them all from the children's perspective. So there's certainly a great deal of work being done with respect to children's rights, and children do have there's a tendency, right, to focus on federal constitutional law. There are some state constitutions that are far better at protecting children's rights than is the federal constitution. And so there's some activity in those states, including in the environmental area. So it's a parallel movement. It's harder to ground all of children's rights claims in the federal constitution, much easier to ground them in state laws. For many states, for example, allow children to consent to mental health treatment after the age of 12. So those issues are out there. And thank you for raising them. They're incredibly important. And it's incredibly important to think about how we let children speak in all of these debates.
Thank you. I don't, if anybody else wants to weigh in, we probably have about a minute or so, not even, but I'll give our panelists, anyone?
I just want to point out that the U.S. is the only country that has not ratified the Convention on the Rights of the Child, right? And so that just tells you, it really tells you about the status of children's rights and how we haven't recognized children's rights to the extent that other countries have. And so doctrinally, there's just a lot more support for parents' rights, which is deeply problematic.
Thank you. So we'll wrap it up. I think, do we have a CLE code that I'm supposed to be announcing? Yeah. So that'll go up on the screen in a minute and then I'll say it aloud as well. But I guess in the meantime, let's thank our phenomenal panelists for this.
Thanks to you all as well, and thanks for the questions.